All right, good afternoon, everybody. My name is Andrew Schaefer from Trafalgar. Welcome. Thank you very much for joining us this evening. Just a few general comments before I introduce our guest speaker, special guest, and my colleagues. Firstly, I hope the transition to a Teams platform was smooth and seamless. We had a few technical reasons to want to migrate, so tonight on Teams, we hope it goes well. Teams doesn't seem to allow a survey link at the end. So a reminder that Karine will circulate the recording link, which will be a YouTube link to all those that have registered, as well as the slides that are covered tonight. And in that email will be a short survey link. If you wouldn't mind completing it, it'll take 30 seconds. It's just a good way for us to collect feedback on topics you would like us to cover, any suggestions to improve these training webinars. And the recordings will also be linked to our training webpage, which is training.trafalgar.coza. Another reminder that we've just added a fully trained chatbot to our training site called TESS, which is Trafalgar's electronic support system. TESS now allows you to ask any technical questions covering any training material, webinars, the notes to those, as well as all the legislation which is loading on the training website. So it should be quite a quick and convenient way to get quick answers to technical questions. And there's always a link to be in touch with Karine, who will provide backup support to that. So hopefully it makes the training website fast and efficient and useful. And please give it a try, training.trafalgar.co.za. This is our second last webinar of the year. We are planning the final webinar for November. Will be on the Thursday, the 27th of November, same time, 5 p.m. We're going to be covering the topic of insurance for bodies corporate and looking particularly at risk assessments and how to be prepared for an insurance risk assessment, how to manage claims effectively, what to be aware of to make sure a claim will be honored, and then also at replacement value surveys, how they're done, what they mean, what happens once the survey is done, and really just all the important points about community scheme insurance. So please join us for that. It'll be the last of the year. We'll then go into a holiday period, year-end recess, and aim to pick up the series again next year in February. So that's on the cards. But once again, thanks very much for joining us for this evening. We felt this topic of navigating conflict and challenging personalities in community schemes is a really important one. And I think many of the attendees this evening who might be trustees or directors or, owners as well, if you've been in these community scheme situations for a long period of time, you may well have come across conflict, challenging owners, residents, and personalities, and really just difficulties handling disputes and disagreements. And this can be very tiring. It can take a lot of time. It can wear a lot of people out. It certainly can dampen enthusiasm for residents and owners to serve as trustees and directors, which is a pity because, it's ideal if there's positive engagement and certainly time-efficient way of managing community schemes as well. So, we wanted to touch on this topic tonight. And so I'm very pleased and thankful to welcome our special guest this evening, Nicole Nell. Nicole Nell is a senior community scheme consultant and mediator from TVDM Consultants. Nicole, welcome, and thanks very much for joining us. I'm going to introduce your bio shortly, but welcome to Karine, my colleague, and Peter, who manage all the logistics and the other sort of mechanisms of our webinar. So thank you both too. And it's great to have everyone here tonight. So just briefly, a little bit about Nicole and why she's ideally placed to present on this topic this evening. Nicole completed a degree in law and a master's in law degree at Stellenbosch University. Her research has involved topics including mediation and specialized dispute resolution techniques. Nicole obtained a distinction with her master's dissertation titled A Critical Analysis of the Community Scheme Ombud Service, How Dispute Resolution in South African Community Schemes can be developed further and improved. Nicole has also completed an advanced diploma in corporate and securities law through UNISA with distinction, and she's also an accredited mediator. So Nicole, thank you very much. I'm going to hand over to you. And yeah, we'll take questions, for breaks, and, let's see how we go with time. But over to you. Thank you so much.
Awesome. Thank you so much, Andrew, and the rest of the Trafalgar team. It's an honor to be here with everyone tonight. I was just thinking, Andrew, when you were mentioning the cool new technology for Trafalgar with the AI and everything, wouldn't it be so convenient if we could also have something like that to deal with difficult owners and trustees and all of those things? But unfortunately, I think that conflict and disputes in community schemes are very much still a human problem. And, tonight we're just going to be discussing some topics and techniques and things like that, tips and tricks on how to deal with difficult owners and flexible trustees, what you can do in online versus in-person meetings. And, like Andrew said, open it up for questions. And then before we wrap it up, I would just like to leave everyone with my top 3 tips of dealing with conflict in community schemes. Awesome. So, Karen, if we can go to the first slide, please. Okay, so I think that the first and foremost thing that everyone should understand is that conflict in community schemes is totally normal. You've got, especially in sectional title, you've got people living in extreme proximity to each other, especially in, a rainbow nation, South Africa. You've got people from different cultures, different walks of life, different ages. It's totally natural that some conflict is going to arise at some time in some shape. And the important thing isn't necessarily avoiding conflict arising, but rather how it's dealt with by the trustees or by the people involved in the conflict themselves. And, if it is a situation of a matter that can be resolved by the trustees of the body corporate, because I'll touch on this later, it's not always possible for the body corporate to solve your problems. It needs to be reported and addressed to the body corporate and the trustees as soon as reasonably possible so that the reasonable action can be taken and, internal dispute resolution processes can be implemented within the body corporate. You can go over to the next slide, please. So, the first thing that we would like to discuss this evening, or I would like to discuss this evening, are strategies to deal with difficult or disruptive owners. So this could be disruptive owners in the context of, just bad behavior. Unfortunately, I've been involved in a few bodies corporate, I mean, my own included, where, every once in a while you get those difficult owners or their tenants that just seem to have no regard for the body corporate rules and the importance of abiding with them. And if you have an instance like this, of course, in the event of contraventions of the Sectional Title Schemes Management Act or any of the CSOS approved rules of the scheme, you need to first warn the owner either of their direct bad behavior or contravention, or the contravention of their tenant or visitor, guest, contractor, anything like that. And I cannot reiterate this enough to community schemes, but, besides escalating a matter to the relevant legal forum, there is only really one power to deal with disruptive behavioral issues within the scheme, and that is unfortunately through, a warning, fining, and a penalty system. And the CSOS have reiterated that many, many times. And of course, the important basis of any warning or penalty system is that it, of course, needs to be reasonable, and a paper trail should be included throughout every step of the process. So, the warning letter followed up with an opportunity for the offender to meet with the trustees, the discussion of the trustees as to whether they will uphold, withdraw, or increase the penalty. All of those sorts of things need to be recorded accurately, such that if the matter is escalated to a legal forum, it's easy for the body corporate to stand firm in the decisions that were made and that they were always made on reasonableness principles. Of course, then, if fines do not address the issue, the body corporate can always escalate to the Community Schemes Ombud Service, the CSOS, or to court if the issue falls outside of the mandate of the CSOS. And a unique thing that we like to recommend to our colleagues and our managing agent colleagues is that your obligation and the trustee's obligation to interact with members of the body corporate is, very purely restricted to matters that only affect the body corporate and matters that are highlighted in terms of the Sectional Title Schemes Management Act. So, if you are getting constant WhatsApps from owners, or you're getting stopped in your weekly shopping trip to Spa by an owner who wants to complain, you need to remind them that complaints and disputes need to be followed through a strict formal channel, which in the case of community schemes would be through email, and only body corporate matters will be addressed. Another way to address issues would be one-on-one meetings, perhaps with, a disregarding owner of the rules, sitting down, meeting with them, trying to find out what the actual issue is behind the bad behavior or the contravening behavior, try to negotiate, reach a resolution, essentially try to mediate the situation before the dispute spirals out of control. And then, of course, something that we like to recommend a lot if there are, a few behavioral issues happening within a scheme and, the trustees are unsure as to which avenue should be pursued, take it to an informal meeting with the members. Try and get as much participation and as much engagement with the members. I think that it's very lonely being a trustee sometimes, and I think that we sometimes forget that we don't have to do it alone. Yes, we are the duly elected representatives of the body corporate, but we still need to make important decisions with as much member participation and input as possible, if possible. So these are all very important things that, can be applied and considered when dealing with difficult or disruptive owners in general. Thank you, Karen. The next slide, please. Perfect. So the next category of persons that we would like to discuss is dealing with difficult or inflexible trustees. And it's important to note that I often see owners launching applications at the CSOS because, they are having extreme difficulties with the trustees and they just want the trustees removed. But I really would like to take this moment to highlight that, unfortunately, the CSOS cannot remove the trustees through a dispute resolution application. There is another mechanism which I'll touch on shortly, but it just reiterates that if a body corporate or if a member or a group of members is really struggling to engage with trustees, or perhaps the trustees aren't acting compliant to the Sectional Title Schemes Management Act, and there are various issues within the scheme that aren't being addressed, the power is really still within the hands of the members to do something about that. And I mean, in this respect, it would be in terms of Prescribed Management Rule 17.4a, the most traditional route would be for a special general meeting to be called upon the request of 25% of owners holding 25% participation quota within the scheme, calling a special general meeting with ordinary resolution business, so 14 days notice for the removal of the trustees. I think something that people don't always think past, though, is that, of course, if you remove the trustees, someone needs to take their place. And when a scheme is going through difficult times, or people are struggling to find reputable persons to serve as trustees, there's a wonderful new mechanism in terms of the Sectional Title Schemes Management Act, and that, of course, is the appointment of an executive managing agent. And I know that Trafalgar offers this service, and essentially it's having professional persons, an entire company with a full backup support staff, step into the shoes of trustees and independently and impartially deal with all management and administration aspects of your scheme that would traditionally be dealt with by the trustees. It's important to note that you will also still have a managing agent with an executive managing agent, but I've seen wonderful changes in bodies corporate where they've experienced these issues of lack of reputable persons to serve, things not being done correctly, so many non-compliances with the Sectional Title Schemes Management Act, and then the members take the decision to appoint an executive managing agent, and within a few months it's like the body corporate does a complete 180. And I think what's important here is that when I mentioned that the CSOS doesn't have a process for the removal of the trustees, it does have the process for the appointment of an executive managing agent in terms of prescribed management rule 28. And this is also done upon the request of 25% of members. So these are important things to keep in mind if you really and truly are struggling to engage with rigid or inflexible trustees. But, similarly to dealing with difficult owners, it's so important that you keep a record of how you really have tried to engage and try to work through the impasses before, it's taking it further to the CSOS or engaging with other members on the issues. Thank you, Karen. Next slide, please. Perfect. So, handling disruptive behavior specifically during community scheme meetings. I've been in quite a few meetings where there's been a bit of bad behavior, both online and in person. And I've seen very, very strong chairpersons step up and deal with those people accordingly. And, again, the chairperson, this is truly within your power, whoever is chairing the meeting, because the prescribed management rules give you the power to manage and control and direct the behavior of the members within the meeting. And I always kind of prefer online because, it's less. It causes less conflict, I would say, in the sense that, the chairperson, when we are online, can always warn the person, give them a warning, say, listen, XY, if your behavior continues like this, I'm going to have to mute you and we're going to have to move on to the next person, or we're going to have to continue with this point. And, if the bad behavior then continues after the warning, you can go ahead and mute them. And of course, if they are still disruptive after that, you then have the option to remove them from the online meeting completely. And of course, then once someone is removed from an online meeting, on Microsoft Teams or Zoom by a host or by, the person who's in the tech background, they cannot rejoin the meeting. And that is important. And if that is the case, as well as in an in-person meeting, it's so important that, that is recorded in the minutes, so that if the person removed ever tries to dispute it, it's actually been recorded in written record in the body corporate's records. Because I know often it's easy to say, oh, we have the recording and all of those things. But in my experience, CSOS if it does go to the CSOS, they are a bit reluctant to open recordings. I think it's because you have to send it through a third-party media or something. But it's always just best to keep everything in written record. I don't know what it is about digital records, but they seem to be lost a lot easier. So always best to try and keep them in them, or to include something like this if someone is removed and on what basis. Always include it in the meeting minutes, as well as the reasons why. And then in person is a bit more conflicting or combative, I would say, because the chairperson would really need to step up then and, take on an assertive role if someone is continuing to be disrespectful, disruptive, rude to other participants or members, things like that. Of course, similar to being online, you can ask the person to leave because the meeting won't be able to continue because of the disruption. And if the person refuses to leave, the chairperson does have the power to adjourn the meeting to the following week. Of course, though, that's not necessarily going to solve the disruptive behavior, but it will at least give, all the members some time to cool down before they come to the next meeting. And hopefully, that member might send a proxy for the next meeting. Next slide, please, Karen. Okay. So addressing persistent noise complaints and dealing with noisy neighbors is probably my least favorite type of contravention to deal with, simply in the sense that it is incredibly subjective. And what I mean by that is, what I would consider to be a nuisance versus to what, the person sitting next to me might consider to be a nuisance are two different types of, levels. And in this respect, it's very difficult when one person complains, and the trustees have to investigate, and they then come back and they find that, there actually isn't an issue. I've been in a lot of cases and matters where people have, lodged noise and nuisance complaints against other owners within a scheme. However, when security or the trustees go and investigate at random times to try and prove the contravention, they can't prove same. And I think it's really important now to highlight that if you are going to make a noise complaint or nuisance complaint or anything similar like that, you need to be able to qualify it with the relevant evidence. So, for example, if your scheme has a rule that says no noise after 10 o'clock, and your neighbor has people over and it's 11:30 and they're still going on all of those things, take a video. The video will have the timestamp. It will be able to capture the noise. It won't be a violation of anyone's privacy or anything like that, because you'll only be sharing it with the trustees and or the managing agent or the executive managing agent as proof and as evidence of your complaints. And these are all, very important things to think about. I know it's extremely irritating when it's 11:30 and you're trying to sleep and your neighbor's being noisy, but we need to realize that the trustees quite literally can't do anything. If they're only getting a complaint from one person and it's not supported by any kind of evidence. And, I know a lot of people might not want to hear this, but first and foremost, you should try and go and speak to your neighbor or the person that's causing nuisance and try to resolve it between yourselves amicably at first, because if it is a noise or a nuisance issue, it is, of course, subjective and personal. And if you and the contravener can come to some kind of agreement along some lines, then, of course, it's always better before it gets escalated to the trustees and they would have to impose on you all of these requirements for evidence and proof. And it might even escalate into a CSOS application, which, of course, is always unpleasant and no one wants to be involved in legal action. However, if it does get to the point where you've tried to resolve it personally, the trustees have stepped in and tried to resolve it as well, and there's been no success, then of course, you as the affected party can always approach the CSOS in terms of section 39(2)(a) of the CSOS Act for an order declaring that this person's behavior is a nuisance, and that an order be granted that they are to desist with the contravening behavior that's causing the nuisance. Of course, receiving the adjudication order won't necessarily stop the bad behavior, but then at least the owner or the affected person has further mechanisms to, perhaps approach the High Court, have the adjudication order enforced as a High Court order, and then served on the contravener. And then they, of course, would be subject to a contempt of court fine or contempt of court application if they continue to refuse to abide with the CSOS adjudication order, which was handed down. Because it's very important to note that a CSOS adjudication order carries the same weight as a High Court order. And that's why it's very easy for any party in a CSOS adjudication, once the adjudication order has been handed down, you simply approach your nearest High Court and you ask them to file the adjudication order, and it receives a High Court reference number and can then be enforced on the guilty party, for lack of a better word, by a sheriff of that court, which is, of course, always, an unpleasant thing to happen. And then, of course, the offending party is subject to further action by the High Court itself. Cool. Thank you, Karen. The next slide, please. Okay. what is the best way to respond to owners who frequently complain or raise grievances? So I always know in some schemes there's always one person who, no matter what the trustees do, no matter what action they try to take to resolve issues, some people are just not satisfied. Alternatively, it's always possible that they do live in a difficult scheme, and there are just unfortunately quite a lot of people that are exhibiting bad behavior. So, if you are one of those owners or occupiers who um, would like to raise grievances and bring things to the attention of the trustees, it's important to note that any complaints needs to be formally submitted. So, as we spoke earlier, through the relevant body corporate channel, which would be email, and it needs to be in writing, supported by some kind of evidence, either proving a breach of the conduct rules or the provisions of the Sectional Title Schemes Management Act. It's important to note, and like I mentioned, the trustees can only step in when it's a breach of the rules or a contravention of the Sectional Title Schemes Management Act. If owners are unsatisfied with, how trustees attend to complaints, handle grievances, they feel that perhaps the trustees are not being impartial in resolving the conflict, they can, of course, approach the CSOS if the CSOS has the power to deal with the relevant dispute. And like I mentioned earlier, if the dispute does not fall within one of the 7 categories that the CSOS has identified as prayers of relief that they are capable of granting, a person will not be able to approach the CSOS for relief. And then the only other alternative would be to try and pursue the matter through a civil court and try and obtain relief in that way. The next slide, please, Karina. Excuse me. So there is in my experience, a large shift in the demographics of ownership and just, residence in community schemes in South Africa. And like I mentioned at the start, it's natural that, with the Rainbow Nation, people are going to butt heads and conflict is going to arise. But it's important to remember for everybody, the trustees, the owners, everyone in the body corporate, that the trustees are the duly elected representatives of the body corporate. They are there to act in the best interests of all of the members. If people feel that the trustees are not impartial or not fulfilling that statutory duty of acting in the best interests of all of the members, then it needs to be taken into account that further action must be taken by the members. And if it is an unfortunate situation of a body corporate where there are simply no people that want to serve as trustees and representatives and take on this fiduciary responsibility to all owners within the scheme, then unfortunately the only other option is for the body corporate to appoint an executive managing agent. However, if your body corporate is one of the lucky ones and you do have trustees that put in the effort and work hard to, represent all of the members' interests within the scheme, then we always recommend that you try to have trustees from as much of a mixed life group as possible. So, different ages, different qualifications, different backgrounds, just trying to get an assortment of people together that can collectively consider different elements of decisions and make the best decisions as a collective group. And, of course, we also further then recommend that if you are able to have trustees as a body corporate, to then always keep this as an uneven number, because unfortunately we find that when a scheme has an equal number of trustees, of course, then the chairperson has to exercise their casting vote. And unfortunately, we have seen that, especially if, it's got to deal with an owner's request to perhaps undertake to work to their section, or, perhaps in light of a complaint or a dispute, and it's the chairperson that has the casting vote, and that casting vote does not go in the way that the applicant owner wishes it would, we always find that they then allege that there was bias and the trustees and the chairperson are not impartial and that there's a conflict of interest and all of those things. So in summary, to dealing with fostering collaboration among trustees with different personalities, different perspectives, if you are able to, as a body corporate, it's important to try and have as wide a representation of people as possible. And if you are unable to, then unfortunately for the body, well, not unfortunately, but fortunately, there's a mechanism in terms of the Sectional Title Schemes Management Act that allows you to then appoint a professional who will independently and in full compliance with the Sectional Title Schemes Management Act take over that responsibility and the duties that should have been performed and exercised by the trustees into their own hands. And then just to summarize some things, or to summarize dealing with disputes in general, if you are either an affected person or if you are the trustees who the dispute has been escalated to, I just want to share some tips on, how I think it's best to effectively deal with conflict in schemes. And I would say that the number one thing, and I know it sounds incredibly cliche, and it's always difficult to do. I struggle with it in my personal life all the time, and it's you have to stay calm and you have to stay as impartial as possible, which I know is incredibly difficult, especially when you are the owner or you are the occupier and this is your home and these things are affecting your way of life and your home life and your peaceful environment. But unfortunately, no dispute has ever been efficiently resolved when people get hot-headed or impatient or anything like that. And I understand that it can be frustrating at times for owners who might feel that they're not getting effective enough responses, or they're not getting the relief that they should be getting from the body corporate. But it's important to note that when you are living in a body corporate and you are dealing with a group of trustees are volunteers. They're not getting paid for all of the extra time and effort that they're putting into ensuring that the body corporate is effectively running well and being managed well. And I think that sometimes owners can forget this and can sometimes expect that the trustees and the body corporate need to solve all of their problems. But unfortunately, you being the owner or the occupier also need to take some not responsibility but perhaps initiative and try and resolve it first amicably. But the first step to amicably resolving any issue is, of course, remaining calm, remaining impartial, stating your side of the story calmly, collectively, and then of course allowing the other side to respond and give their side of the story. And when this is happening, it's so important to note that you actively actually need to listen to the other side, which I know can be very difficult, especially when, you feel that you have experienced an injustice or people aren't hearing your side of the story or your point of view correctly. The second thing is you need to have all of the facts. You need to be sure of yourself before you go launch a complaint or go to the CSAS. Too many times I've seen matters go to the CSAS where either the applicant or the respondent has really just not taken enough of an effort to um, to go ahead and research the history of the matter, or They don't actually know what happened regarding the other side of the story. And then I always feel it's very difficult. If someone responds to a CSOS application and they provide perfectly adequate responses and explain all of the issues away, and if you had perhaps just asked the right questions before approaching the CSOS, it could have been resolved way sooner. Because we do know that, unfortunately, at the CSOS, if you are launching an application for dispute resolution, you are going to wait a little bit, at least a few months, before an adjudication order might be handed down. And of course, if you escalate the matter through the court, you could be looking at a few years before you get an order or your time in court, if that's what you want. And then just the last thing I'd like to mention is that if you, as the trustees or the owner that's being approached by an affected party, can't assist or help resolve the dispute that an owner finds themselves in, there is an obligation on you to inform that person and say, sorry, AB, I can't assist. It's not within our mandate, or it would not be reasonable or in the best interest of the body corporate for us to involve ourselves further in this dispute. Give them reasonable reasons as to why, you can't engage further on this matter or how you can't assist further in the matter. And then most importantly, refer the people to the correct forum where their matter can be resolved correctly. So, for example, if it's a dispute that falls within Section 37 of the CSOS Act, refer them to the CSOS, refer them to the CSOS's website, refer them to the CSOS Consolidated Practice Directive. I know it's an incredibly long read, but everything that people would need to know about how to submit an application for dispute resolution is in there. And if it's not the CSOS, tell them, listen, this is a potential damages claim that you have. The CSOS don't deal with damage claims, but because your claim is only for 8,500 Rand, why don't you consider going to the small claims courts? Because they, of course, it's under 20,000 Rand. There's no legal representation. Each party represents themselves and states their case to the presiding officer, who makes an order there and then on the day. So those, I think, are the most important things that I like to think about and consider when, involving myself in a community scheme dispute. And also, if I've butt my head against the wall with the trustees, with the affected parties, and there really is no way for us to move forward and resolve it amicably, it's important to know when to stop so that the relationship doesn't deteriorate between yourselves further, and then to refer it to the correct independent legal forum to make, an independent order and hopefully settle the matter once and for all. Cool. Thank you. I
Nadine.
think that's all that I have to say.
All right. Well, thank you very much indeed. That was very informative. We got a few questions and then just a few other topics we can refer to. So why don't you just talk a little bit about homeowners associations, how they may either be the same or differ to a body corporate in terms of the way that disputes should be dealt with or escalated.
Yes, of course. So, yes, unfortunately, homeowners associations and other types of community schemes are often not referred to as often in dispute resolution situations. And I think that it's because, for many reasons, the CSOS and the SDSMA are so interlinked. However, the process between bodies corporates and homeowners associations don't really differ that much. I mean, in terms of the types of rules for penalties and fining and those types of things, the bodies corporate are of course bound in terms of fines by, you cannot impose a fine that is higher than the monthly levy contribution that an owner is paying. That's in accordance with the CSOS practice directive and what they deem to be an undesirable rule in terms of the Sectional Title Schemes Management Act. However, in terms of that same consolidated practice directive, the same rule is not present under potential undesirable rules for homeowners associations. So that of course then begs the question, or the assumption rather, that homeowners associations, especially considering that things like security, access control, and unfortunately the biggest issue, building and aesthetic deviations are dealt with very differently in a homeowners association compared to a body corporate. However, the most important thing that a homeowners association must remember is that regardless of the fining amounts and the process that's followed after the implementation of a fine, it's still so important to note that if you do not have a penalty or a penalty process in place that first provides for a warning letter, in the majority of instances, of course, in a homeowners association, if someone has, knocked down a house, you can't send them a warning letter. But when it's reasonable, always send a warning letter. And if the bad behavior persists or the contravention occurs again, then you may implement a fine. But similarly to a body corporate, just ensure that everything has a paper trail. And the only difference that I think is important to note in a homeowners association is that, unlike bodies corporates, you do still have the option to pursue disputes through arbitration. However, it must be noted that in order for a matter to qualify for arbitration, there does actually need to be a dispute. And I know that that might seem silly to say, but it's important to note that a dispute is not necessarily just a differing of opinion or something like that. There actually needs to be something in dispute, and someone needs to be, or the arbitrator then would need to make an independent decision on that. However, it's our recommendation that if a dispute arises within a homeowners association and it is within the jurisdiction of Section 39 of the CSAS, to then approach the CSAS, because of course arbitration is still quite an expensive process, whereas the CSAS is free to use.
Thank you very much, Nicole. Next question, pets that are nuisances.
Yes.
And dealing with those. So why don't you just talk a little bit about, how that should be best dealt with, to kind of collaborate with the parties.
Yes. So pets that are nuisances. Sorry, it's difficult for me to, not difficult, but I love pets, of course, but I'm lucky because I live in a scheme where you're only allowed to have an inside cat, so the nuisances experience are very little. But I have been involved in many instances where I've heard very, very terrible things of pets constantly fouling the common property, dogs barking for, an hour straight, terrible, terrible things that I know I would hate to live next door to. And the thing is that it's important to have, number one, pet rules in place. So you obviously need to have, if your scheme is pet friendly, you have to have some kind of approval process before someone can bring a pet into the scheme. And that needs to consist of, them being up to date with their vaccinations, them being sterilized. If there are size or weight or other limitations on specific types of pets that can be kept, this needs to be taken into account. And and of course, then the all important is having rules that say owners are fully responsible for the behavior of their pets. Pets cannot cause a nuisance to other residents through excessive barking, excessive meowing, causing a nuisance by transversing over other people's sections, over parts of the common property that other people are enjoying. And the important thing is that the owner signs that application, and once the approval is given by the body corporate and the owner through their pet, or the pet or the owner directly then contravenes any of the rules relating to the keeping of the pet or the pet causing a nuisance, what needs to happen is the warning letter, giving the owner an opportunity to correct their pet's bad behavior, which, of course, in the instance of something like fouling common property or minor issues that can be corrected by, a human intervening, it should be easy. But when you've got an issue of an incessant barking situation or an aggressive dog that, people are afraid to be around when it's on common property, The trustees then need to revoke the approval for the animal to be kept. And this is very important. Once the approval is revoked, neither the body corporate nor the homeowners association nor any kind of community scheme have the authority to remove the animal from the community scheme. That power rests solely within the hands of the owner of the pet. And you also will not be able to contact the SPCA or tiers or anything like that, because in my experience and our experience at TVDM, they will only intervene if there is maltreatment or abuse of the animal. So what does that mean? So once the approval is revoked by the community scheme and the owner of the pet refuses to remove the animal, the only alternative, or the only subsequent option rather, that the community scheme has is to approach the CSOS in terms of section 39 2D, on the basis that the animal or the pet is now being kept illegally because the approval or the authority for it to be kept has been revoked, and that you would like an order for the animal to be removed from the scheme. And I have actually had quite a few successful orders handed down by the CSOS in that regard.
Thank you, Nicole. Could I ask everyone with a question, please just to type it in the Q&A. That's going to be easier to curate the questions and just to direct them to Nicole. So please use the Q&A and we'll get your questions in that particular form. Nicole, the question from David, trustees who break the rules themselves, or potentially are not proactive and, meeting their responsibilities in terms of enforcing the conduct rules, playing their part in terms of resolving disputes. What is your advice in those circumstances?
So again, like I mentioned in the presentation, my advice is that the owners need to take the power back into their hands. And if they are upset about how, the trustees are acting, they need to call the special general meeting, have them removed, perhaps consider running or appointing themselves or nominating themselves or other people they trust as trustees. Of course, then if that's not an option, then the only other alternative is to approach the CSOS or the other members for the appointment of an executive managing agent. There is a new process at the CSOS, but I must be honest, I don't have direct personal experience with it yet. I do have a matter where we are requesting for this to take place as part of an adjudication order that's handed down. But I believe that the CSOS have recently established a compliance and enforcement division. And if your body corporate or the trustees rather are non-compliant with various provisions of the Sectional Title Schemes Management Act or the management rules or the conduct rules of the scheme, I believe that any owner would be able to make a request to this department, and they, I believe, would come and physically investigate the scheme and interview persons within the scheme to then determine the level of compliance of the body corporate. And they could then even issue fines to the body corporate if they were to continue with the non-compliance of the Sectional Title Schemes Management Act.
Okay, thanks, Nicole. What is your advice in terms of dealing with an owner or a resident that literally barrages the trustees, the managing agents, whoever they can find, with their dispute, and, no amount of responses or efforts to assist really dissolve that, because, some of those personalities are not interested in differing views, in objections to their approach, etc. And, one gets to a point where with repetition and just volume, it becomes unmanageable, to respond or deal with them further. So any tips on how to deal with those sort of personalities?
Yes. So we have, unfortunately, a lot of experience with that. And what we always recommend for the trustees and the managing agent to do in those instances is essentially draft a once and for all final correspondence on because as I understand it, it's usually the same matters that these owners keep on highlighting and bringing up and reiterating. And, the trustees and the body corporate have already addressed it numerous times, but unfortunately, they're just not happy with the answers that they're getting. And
Yes.
in that respect, our recommendation is the body corporate drafts a formal letter, perhaps on the managing agent's letterhead, and it says, listen, sir, we have corresponded with you several times on these issues. This will be our once and for all final correspondence on these on these matters. You provide the final answers as you probably have done 100 times in the past. And then at the end of the letter, you will say, this will be our final correspondence, and we will not litigate further by correspondence. And then you put the power in that owner's hands, because if they have legitimate complaints, they can approach the community schemes ombud service and launch an application for dispute resolution. And then the body corporate will be able to prove, look how much correspondence, look how much time we've already expended on this owner and trying to address their problems reasonably. But unfortunately, it seems that everything we're doing is not appeasing the situation.
And Nicole, a step beyond that, would it be worth going for a nuisance complaint? So the trustees would need to then enforce it further by getting a nuisance order from CSOS as well.
So they could try that. I have tried that sometimes at the CSOS, but unfortunately I have yet to be successful. As the CSOS is of the opinion, or at least the adjudicators that at the time that dealt with the matters that I dealt with, um, they didn't believe that it qualified as nuisance for an owner to be corresponding with the body corporate, even though, in one instance it was like, I think 37 times in over 2 days. But the CSAR still felt that that was reasonable. So in my experience, my personal experience, I've never been successful, but genuinely, I can't believe that if you are getting like, and I know that there are some schemes that have owners like this that get over 100 emails a week from one owner. Approach the CSAR, see if you would be successful. I mean, the I like to think of CSAS, because it is lower, it's free to use, but of course people like to use maybe their managing agents or your services or our services or any professional service perhaps for assistance in a CSAS application. It's worth trying if it could bring relief. But just out of interest, I know that if you have like a serial complainer in terms of civil court, there is a mechanism where you could apply for someone to be declared as a vexatious litigant. And I know of similar instances where there are sometimes owners in bodies corporate that just launch CSOS application after CSOS application after CSOS application. And I've inquired at the CSOS, does a similar mechanism exist, like it does in court for, vexatious litigants or something like that? And they've unfortunately said no, and that a body corporate or any community scheme will always unfortunately be required to respond to any application for dispute resolution that's launched against them.
And Nicole, now, in terms of lodging a dispute, so let's say a particular owner approaches the trustees with a dispute, and the trustees do their best to resolve the matter, but unsuccessfully. Is it for the owner then to lodge the dispute direct with CSOS, or should the trustees now be the parties that lodge the dispute and then take it further on behalf of an owner who's not having success with resolution?
In my opinion, it should be the owner, simply because the body corporate, like I've mentioned, they can only really do so much. And in the instance of, I know, like, for example, a popular example is if there is leaking from the upstairs balcony or something like that, and the body corporates have sent the owner a letter and have asked them to intervene, and they're not doing anything, but it's causing severe damage to the downstairs unit. Of course, then the body corporate could intervene in terms of prescribed management rule 31, for example. But if it's like an instance of nuisance, it, in my opinion, wouldn't be fair for on all the other members in the body corporate for the trustees on behalf of one owner to pursue that application, unless, of course, getting an order confirming nuisance would be in the best interest of the body corporate as a whole. But again, if it's only a single owner that's being affected, I think that it could be difficult to prove that it would be reasonable to do that. But also, that being said, the body corporate could also perhaps be a co-applicant or even be a second respondent in the application. And then if they are a second respondent for the CSOS application, which means they're the second person that the application is being made against, with the first person being the contravening owner or whoever, the body corporate will then provide a formal response on how they dealt with the dispute to the CSOS, which will then also provide the adjudicator with some clearer context of the internal dispute resolution that's taken place, and perhaps give him a better idea as to how to make an order on the matter.
Mm. Nicole, not tenants. That can be a complicating factor because, they're one step removed from the owner. The owner might not even know what the conduct of the tenants are. How does one deal with tenants now that are not, following the rules and are causing nuisances and, are now part of a dispute?
Mm. So with tenants, the first and foremost port of call is the owner. So owners, whether they have a direct relationship with their tenants or not, the body corporate's point of contact is the owner. So if they get a complaint from a tenant, for example, it's important to include the owner or CC the owner in the response when they're responding to the tenant about potential steps to be taken forward. And if complaints are brought against the tenant, the first thing to do is forward those complaints to the owner and let them know, we are going to be issuing you with the warning letter on behalf of your tenant, and it's your responsibility as the owner to come to an agreement with or not come to an agreement, but essentially put your tenant on terms to comply with the conduct rules. And just a note, the body corporate or any community scheme can't place any kind of pressure on an owner to remove a naughty tenant. Unfortunately, the power of eviction is solely in the hands of an owner, and even that is incredibly difficult. And then with regards to if an application is being brought because of bad behavior against a tenant, it's always our recommendation that the first respondent would be the owner, but then the tenant would be cited as the second respondent. And also similarly, if a tenant was launching an application for dispute resolution, we would always recommend that the owner is included as a co-applicant or a second applicant, just so that the CSOS and the body corporate is aware that the owner supports the application being made and is fully aware of what's going on.
Great. Now, what do you think the role of the managing agent is, Nicole, in terms of trying to mediate or defuse or even resolve disputes?
So I think that I, I think that it's of course possible that the managing agent could play a role, but I think that it's a very difficult position for a managing agent to be put in, because of course you are an employee to the body corporate, and you would always put the body corporate at the front first and foremost, but it might not be in the body corporate's interests in a dispute. And that's why if someone is going to be mediating a dispute, it should always be an impartial third person that is in no way connected to the dispute, and in an ideal world has no prior knowledge of the dispute, because then you can solely apply your mind to the situation on the facts as they're presented to you that day, and you can then try and work on a resolution. I know that even if it was any person that had relation to the body corporate, if one party didn't get their way, they're of course the first thing that they're going to allege is that there was bias because the managing agent is employed by the trustees and the trustees pay the managing agent's salary, because we all know that's a popular one that's said. So I think it's perhaps best to avoid any further accusations of conflict of interest or any further disputes that may arise from the original dispute, to rather just let the managing agent facilitate the setting up of the dispute resolution discussion and providing the relevant documentation when necessary, but just trying to keep themselves as that information repository of the body corporates.
Excellent. Well, Nicole, thank you so much. We are out of time, but thank you very much for some very good suggestions and lots of experience. So you'll see contact details, everyone on the slide. You're welcome to get hold of any of us. If we can help, we certainly will. And certainly this is a big ticket item in community schemes. And if disputes can be managed well, if they can be managed efficiently and referring quickly to the right channels and forums, I do think it goes a long way to resolving them quickly and with as little strain as possible on the parties concerned. So thank you very much for joining us. We appreciate it. I hope you have a good evening. Please look out for the recording link if you would like it, just to keep it as a reference. The recording will be posted on our webinars training page as well. And we look forward to you joining us in November for the insurance webinar topic. Hope you have a good evening, and thanks once again for joining us. Thank you, Nicole, Peter,
Thanks so
Karine.
much,
Thanks
Andrew.
all. Okay.
Thanks, everyone. Have a good
Good
evening.
night.
Bye.
Bye. All right. Good afternoon, everybody. My name is Andrew Schaefer from Trafalgar. Welcome. Thank you very much for joining us this evening. Just a few general comments before I introduce our guest speaker, special guest, and my colleagues. Firstly, I hope the transition to a Teams platform was smooth and seamless. We had a few technical reasons to want to migrate. So tonight on Teams, we hope it goes well.